Hello everybody, I'm Dr. Khushbu Mahajan, Research Fellow at Institute for Development and Communication, Chandigarh. We are today going to discuss the module on institutional arrangement for minorities and special categories in India. When India got independent, it was the mosaic of various ethnicities, cultures, religions, as well as categories. At that time, on the one hand, this uniqueness of India, the diversity of India was to be celebrated, but on the other hand, it projected many differences. Thus, it was a big challenge for Indian Constitution and Indian constitutional framers to address these differences and to address these anomalies with different interventions within the Constitution. Thus, they make legislative interventions and policy interventions specifically categorized as positive discrimination or affirmative actions in which the legislative measures taken for these special categories and minorities. Since there is a component of discrimination towards these marginalized groups, thus these provisions are called protective discrimination, positive discrimination, affirmative action, compensatory discrimination, etc. Such instruments of policy were further supplemented by statutory provisions for these minority and special category institutions. The provisions for these special categories and minorities. The Constitution of India defines special provisions for these categories under fundamental rights, directive principles of state policies, framework of structures, powers and functions within these institutions. In this regard, we'll discuss National Commission for Scheduled Caste and Scheduled Tribes first of all. As mentioned earlier, special provisions have been promulgated in the Constitution for the protection of the rights of scheduled caste and scheduled tribes in India and to promote social, economic, educational and cultural rights of these categories. In order to ensure proper implementation of these provisions, the Constitution of India provided for the provision of special officer for scheduled caste and scheduled tribes under Article 338 of the Constitution. In pursuance of this provision, first time this officer, that was called National Commissioner for Scheduled Caste and Scheduled Tribes, was created on 18th November 1950 by the Constitution framers. Later it was felt that the single member office of the Commissioner of Scheduled Caste and Scheduled Tribes is not enough for providing or monitoring the safeguards for scheduled caste and scheduled tribes. Hence, a proposal was mooted for the amendment of this article and to make it a multi-member body for scheduled caste and scheduled tribes for promoting the interests of these categories. And thus, with the 46th Amendment Act, this single member office was replaced by a multi-member National Commission for Scheduled Caste and Scheduled Tribes on August 1978. The functions of the Commissioner for Scheduled Caste and Scheduled Tribes and the Commission for the Scheduled Caste and Scheduled Tribes coexisted till 11th of March 1992. Thus, the government decided to demarcate the functions of these two bodies and to rename it as the National Commission for Scheduled Castes and Scheduled Tribes in 1987. The National Commission for Scheduled Caste and Scheduled Tribes thus came into being with 65th Amendment Act 1990. In 89th Amendment Act of the Constitution, it was decided to separate the National Commission of Scheduled Caste from the National Commission of Scheduled Tribes. Thus, in 2004, the erstwhile National Commission of Scheduled Caste and Scheduled Tribes was bifurcated into two separate commissions, that is, National Commission for Scheduled Caste and the National Commission for Scheduled Tribes was formulated. The functions, duties and powers of the National Commission of Scheduled Castes have been given in Clause 5, 8 and 9 of Article 338. The major function of the National Commission for Scheduled Castes is to investigate and monitor all the matters relating safeguards provided to the scheduled castes by the Constitution of India and any other law thereof. Secondly, to investigate special complaints with regard to the deprivation of the rights with regards to the members of scheduled castes in India. Thirdly, to participate and advise on the planning process of development, socio-economic development of scheduled caste. Fourthly, to present the President the reports on the working of these safeguards. And fifthly, to make recommendations for the implementation of these safeguards and to discharge any other functions as the President may by law or the Parliament may by law specify. In order to discharge these varied functions, the organizational setup has been made of this commission, in which it has been mentioned that the commission shall have 5 members including 1 chairperson and other members which include 2 honorary members, 1 secretary, 1 joint secretary, 1 deputy secretary, 1 director and 1 deputy inspector general of police and 2 superintendent of police besides technical and administrative staff. It is also supported by the study units dealing with service safeguards, development, atrocities and a number of field officers. The Commission shall also undertake an annual review of human development indices regarding scheduled castes and scheduled tribes, especially pertaining to their education, besides evaluating such centrally sponsored schemes regarding their development, safeguards, service safeguards as well as economic development. National Commission for Minorities. National Commission for Minorities was envisaged in 1978 under the Ministry of Home Affairs. Initially it was a non-statutory body, but in 1984 it was placed under Ministry of Welfare and it was made a statutory body. The National Commission for Minorities became a statutory body and the first such commission came into being in 1993. 5 religious communities, that is Muslims, Sikhs, Christians, Zoroastrians and Buddhists, have been notified as religious communities in India. As per 2011 census, these 5 religious communities constitute around 20.8% of the total population of India. The Constitution doesn't define the word minority, but it refers to the term based on religion and language. And the rights of minorities can be placed under 2 domains. One is the common and the another is the separate domain. Within the common domain, we can consider those rights which are applicable or which have been given to all the citizens of India without any discrimination, while in the separate domain are falling those rights which have been separately given to the minorities of India. The rights which have been placed under common domain comes under Part 3 and Part 4 of the Constitution. Under Part 3, Article 14, Clause 1, 2 and 4, Article 15, Clause 1, 2 and 4, Article 16, Clause 4, Article 25, Clause 1, Article 27 and 28 respectively are the rights which have been placed under this category. Whereas in Part 4 of the Constitution, Article 46 and Article 38 are the rights which have been placed under this category. While in the category of special domain rights, we have the Articles 29, Clause 1 and 2, Article 30, Clause 1 and 2, Article 347 and Article 350 Clause B, whereas the fundamental duties mentioned in Part 51A also come under the common domain. The Commission is required to perform various functions, and for this purpose we would like to play the PPT. Firstly, to evaluate the progress of the development of minorities under the Union and states. Secondly, to monitor the working of safeguards for the minorities. Thirdly, to make recommendations for effective implementation of the safeguards for protection of the interests of minorities. And fourthly, to look into the specific complaints regarding the minorities. Fifthly, to undertake the studies regarding the discrimination and the problems arising out of this discrimination against the minorities in any part of India. Sixthly, to conduct studies, research and analysis on the problems and atrocities faced by the minorities, as well as their educational, social and economic development. Seventhly, to suggest any measures to the state government or the central government regarding the protection of the rights of the minorities. Eighthly, to make specific reports and periodicals regarding the minorities and the issues of the minorities to the central government. And lastly, to look into the other matters pertaining to the minorities as referred to this commission by the central government. Now, what is the organizational setup of this commission, that is National Commission for Minorities? Basically, this commission consists of a chairperson, a vice chairperson and 5 other members of integrity and ability, and these are nominated by the central government, provided that all these 5 members of this commission shall be from the minority communities. The government has also started some new initiatives for the progress and development of minorities, and in this regard the Prime Minister's 15-point program is one. And on the other hand, the government is also thinking of establishing Equal Opportunity Commission and Diversity Index for the access and participation of minorities and other marginalized and socially backward groups. National Commission for Scheduled Tribes. The National Commission for, as we have discussed earlier, the National Commission of Scheduled Tribes has been established by amending Article 338 and inserting a new Article 338 Clause A, in which the erstwhile National Commission for Scheduled Caste and Scheduled Tribes has been bifurcated into 2 separate commissions, that one is National Commission for Scheduled Caste and the other is National Commission for Scheduled Tribes. And in 2004, the National Commission for Scheduled Tribes came into being with 89th Amendment Act. Functions of National Commission for Scheduled Tribes. This commission performs various functions like all the previous commissions, and for this purpose we need to play PPT along with. The first function of this commission is to investigate, monitor and evaluate the matters relating to the safeguards provided for scheduled tribes, and secondly, to inquire into the specific complaints regarding atrocities against the scheduled tribes. Thirdly, to participate, advise and evaluate planning process relating to socio-economic development of scheduled tribes. Fourthly, to submit an annual report to the President regarding the working of these safeguards. Fifthly, to discharge such functions in relation to the scheduled tribes as mentioned to it or as specified to it by the President or the central government. Sixthly, to undertake measures over conferring ownership rights in respect of minor forest produce of scheduled tribes living in the forest areas. And seventhly, to undertake measures to safeguard the rights to scheduled tribes over mineral resources, water resources, etc. as per law. Eighthly, to make measures for the development of scheduled tribes and to work for more viable livelihood strategies. Ninthly, to undertake measures to improve the efficacy of relief and rehabilitation measures for scheduled tribes displaced by development projects. Tenthly, to undertake measures to prevent alienation and effectively rehabilitation of scheduled tribes people from the land. 11th, to undertake measures to elicit maximum cooperation and involvement of scheduled tribes for protecting forests and undertaking social afforestation. 12th, to undertake measures to ensure full implementation of the provision of Panchayats Act 1996. 13th, to undertake measures to reduce and ultimately eliminate the practice of shifting cultivation by scheduled tribes that lead to their continuous disempowerment and degradation of land and environment. And finally, the union and state governments are required to consult the Commission on all the major policy decisions affecting scheduled tribes. Constitution has provided different safeguards for the protection of the rights of scheduled tribes, and these safeguards can be categorized under various points. And the first one is educational and cultural safeguards. These educational and cultural safeguards have been mentioned under Article 15 Clause 4, Article 29, Article 46 and Article 350. Social safeguards have been mentioned under Article 23 and 24, whereas the economic safeguards have been mentioned under Article 224 Clause 1 and 2 and Article 275. Political safeguards have been provided under Article 164 Clause 1, Article 330, 334, 337, 243 and 371. On the other hand, service safeguards have been provided for the scheduled tribes which have been mentioned under the Constitution of India under Article 16 Clause 4, 16 Clause 4A, 16 Clause 4B and Article 335 as well as Article 320 Clause 4. Other safeguards have been provided for Scheduled Caste and Scheduled Tribes Act 1989 and the rules framed thereunder in 1995, as well as Bonded Labour Abolition System Act 1976 and Child Labour Prohibition Act 1986. Religious and linguistic minorities of India. Presently, there is no separate statutory body for religious and linguistic minorities in India. But the religious and linguistic minorities, however, constitute the subject matter of Ministry of Minority Affairs. The Ministry of Minority Affairs, the first such ministry, was created on 29th of January 2006. Ministry of Minority Affairs is required to perform various functions, and these functions are, first of all, to empower the minority communities and to enable and creating an enabling environment for the multilinguistic, multi-regional, multilingual and multi-religious society, to improve the socio-economic conditions of minority communities through affirmative action, protective discrimination, etc. Thirdly, to facilitate an equitable share for minority communities in education, economic activities, cultural activities, etc. And lastly, overall policy planning, coordination, evaluation and review of regulatory and development processes regarding minority communities. In all the matters relating to minority communities except those relating to law and order, then to consult policy initiative regarding the matters related to minorities in consultation with central government, and also the matters relating to linguistic minorities and the Office of the Commissioner of Linguistic Minorities matters relating to National Commission for Minorities Act, questions relating to minority communities in neighboring countries in consultation with the Ministry of External Affairs, charities and charitable institutions, charitable and religious endowments pertaining to subjects dealing within the department, and matters pertaining to socio-economic, cultural, and educational status of minorities, minority organization, including the Maulana Azad Educational Foundation, the Waqf Act 1995, the Central Waqf Council, the Dargah Khwaja Sahib Act 1955, funding of the programs and projects for the welfare of minorities, including National Minorities Development and Finance Corporation, employment opportunities for minorities in central and state public sector undertakings and also in private sector, formulation of measures relating to protection of minorities and their security in consultation with other concerned central ministries and state ministries. National Commission for Religious and Linguistic Minorities. On 29th of October 2004, the Government of India constituted a Religious and Linguistic Minorities Commission to look into the matters pertaining to religious and linguistic minorities in India. This commission was chaired by the former Chief Justice of India, Justice Rangnath Mishra, and this commission was also known as Rangnath Mishra Commission. This commission was entrusted with following functions. First of all, it had to identify or to give the criteria for identifying the backward sections within the religious and linguistic minorities. And secondly, to recommend the measures for welfare of socially and economically backward sections within the religious and linguistic minorities in India, and especially to give them reservation within the education and government employment. To suggest the required constitutional, legal, and administrative modalities for the implementation of its recommendations. The Commission, in the context of its reference, came out with different recommendations, and first of all, the Commission recommended a uniform pattern of identifying a criteria for identifying backwardness. The Commission recommended the involvement of a uniform pattern of criteria for identifying backwardness, which should be based on educational and economic status and not based on their caste and religion, and this should be applicable to all the sections of society irrespective of their caste and religion. Secondly, the Commission gave the opinion that any kind of backwardness, especially social and economic, basically emanates from educational backwardness, and thus it gave various recommendations to provide and to improve the educational status of minorities. Lastly and most importantly, this commission recommended that minorities should be regarded as backward and they should be given reservation in case of employment, and these minorities should be given reservation, that should be 15%, and it should be given to them. In case of Muslims, they should be given 10% reservation, and the other communities, other minorities should be given 5% reservation. For the recommendations of this commission, that is Rangnath Mishra Commission, these recommendations will definitely prove helpful for upgrading the status of religious and linguistic minorities of the country. Thus, after this discussion, we came to the conclusion that these provisions or the provisions of the statutory bodies or the legislative measures or the laws made by the parliament time to time, these have helped in the upliftment of the status of scheduled castes, scheduled tribes, minorities, linguistic and religious minorities, and other backward sections of the society who had faced discrimination since ages, and thus Constitution has provided safeguards for these classes so that they can upgrade their status in future. Thank you.